Someone make it make sense.
Probably a couple.
Yo, 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 what is up, party squirrels? Angel D in the hizzy saying quite appropriately one of our favorite Alex Murdochisms, which is right here.
It's a house.
Love it. It's a house. Party squirrels in the hizzy. Yes, indeed. Oh, I need to, speaking of hizzy, I need to send Twiz his special text. Special text for a special Twiz. Mary is joining us after having 5 vodka cranberries. How very New England of you. And a Jaeger bomb. Wow. Did not win bingo. That's too bad. Maybe next time. Husband's passed out. Glad you guys Ubered home. And you're glad I'm here. I'm glad you're here. We love you. We love you. We love you so much. What's new with you guys? What is new with you guys? She says she's lit. I'm here for it. We celebrate everybody, whether they're lit, unlit, whatever the case may be. What does that mean? Was he on Anjanette Levy's live stream or something? So speaking of Twiz, let me send him a special text. Twiz, where I gotta find my thing and copy and paste. Okay, here we go. Copy. Paste. Okay, cool. It is. Oh, he was in the chat. Oh, interesting. How funny. That's funny. Interesting. Everyone was like that to his. Well, he's basically famous, right? That's why he has a special co-host status, which he's used only once. Mary says she's been overloaded at work. Glad he quit his toxic job. What was it? I don't remember what you said he did, or if you said what he did. But that's good news. Hopefully he has something fun on the horizons as well. Speaking of horizons, after we finish here with the latest out of Ada County, as we say, this should redirect you guys into a members-only live stream as by request and back by popular demand. Jeff and Shalia, after a 3-year hiatus, they are now back and better than ever. And there's lots going on over there. That's going to be super fun. I can't wait. You guys are going to love it. I've already done a little look into what they're up to these days, and it's pretty gaslighty and amazing in that manner. In the way that they are in a way that only they can be amazing. It is that and then some. So it will be very fun. So that will be redirected after this through the magic of technology. So we have some new filings. Woo! I'm so glad I refreshed it. Like, my plan was actually to do Adelson's tonight and then go into the members only live with Twin Flames. And right before I scheduled it, I was like, well, I haven't checked the docket today for Idaho. Let me double check and see. And sure enough, I was like, well, glad I did. So change of plans, got the thumbnail ready, got the stream set up, and we're doing this instead. And we'll do Adelson's a little bit later. So like maybe this weekend or what have you. Mary says it'll be her first members only live. That is awesome. Love it. Celebrating that for sure. So he's still teaching shooting, but his part-time janitor job. Okay, gotcha. Yeah. So he likes the shooting job, right? Teaching shooting. I guess that's guns, teaching shooting guns. Okay. So we want you to be able to stay awake. So let's get going into these new documents. All right. So first up, this is a quickie. That's what she said. We have the amended scheduling order. All right. Nothing too crazy here, but since it's not sealed, we're going to take a look. So here we go. Sealed proceedings with the court and counsel will take place July 28th through August 1st. Voir dire will commence August 4th rather than July 30th and continue until a jury is seated. It is estimated that trial itself, beginning with opening statements, will commence on August 18th and continue until completed. Now, that is actually, I believe, the same date. So that hasn't changed. So essentially, sounds like they're just hoping that they can seat a jury in less time? That doesn't make any sense. Seems like it would be more time after all the documentaries anyway. Y'all let me know if you remember if the initial plan was, I think it was August 18th. I don't think that has changed. So, so there you go. There you go. Okay, so first up, guys, here we go. So as far as the alternative perpetrator evidence, right? Similar to third-party culprit, if you're in Massachusetts, where we just were for quite a long time, here it's the alternative perpetrators. So here we go. So there's been much to do about this, right? They've had these closed, hearings about this. There's been ex parte filings, sealed filings, and we, anyway, we know they had to make an offer of proof, and now we're getting an order on this offer of proof. So we may not learn what their alternative perpetrators, who they were suggesting, but we're going to learn whether or not they will be allowed. And spoiler, it is denied. So, although you may have seen that in the title and or the thumbnail. Oh, it was originally August 11th. Thank you, Angel. Thank you. So they did bump it up then. So that's good. That's good. That actually works out for me because I have I'm doing that notary class thing the first week of August, and so that actually works out well for me. So love that song. It's been 1 week since you looked at me. Do 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 do. Chicken Chinese chicken. Dig dun dun, and your brain starts ticking. Where's Flash when you need him? Speaking of chicken. James, hey, you better re-up your membership so that you can join us for our Twin Flames after this. But also happy to see you. And also shout out Flash, who will probably be here at some point because he loves chicken, fried chicken. There it is. There's Flash's command. So oftentimes whenever I mention Flash, he then magically appears like he's got ESP. It's pretty cool. So we love you guys so much. All right, cool. And Heather had requested, by the way, that we do a Twin Flame. She's been making this request pretty regularly for like a month. And that was before we knew that there was all this new Twin Flame stuff going on. So hopefully she'll be able to join us as well. All right. So introduction. The state, let me zoom in. The state previously moved in limine, seeking to preclude the defendant from offering or arguing alternative perpetrator evidence without first satisfying the applicable evidentiary standards. In accordance with the court's subsequent order on the motion, defendant filed his offers of proof and evidence in support, identifying 4 individuals as potential alternate perpetrators. Now, before I read on, my thought was that this was going to have something to do with, this is pretty logical, right? But the other DNA, the unknown DNA, and the other DNA at the crime scene. But I feel like there weren't 4. Weren't there only 3 others? Anyway, the state objects to the presentation of this evidence at trial, arguing it fails to satisfy the standard under State v. Meister. Defendant conceded at oral argument. At this point, his proffer is not sufficient to pursue an alternate perpetrator theory at the outset of trial, but requests latitude and cross-examination of the state's witnesses to try to establish additional evidence to satisfy the Meister standard. Okay, so this is interesting because we're learning something new here, right? So the hearing that was last week or the week before, whatever, we covered it on the last live stream. They had oral argument on this exact issue, right? But we didn't get to hear the oral argument. So now we're learning that during that oral argument, the defendant conceded, basically agreed that they did not have enough evidence at this juncture. However, they want to have a wide cross-examination or wide girth in cross-examination to try to establish additional evidence. Now, what does that remind you guys of? I'm sure y'all all are like, oh yeah, that's very similar to what was done, or what was done more so in the first trial, but what could have been done if they wanted to in the second trial for Karen Reed. But as we know, wisely, the defense didn't really go as hard into the third-party culprit like they did in the first trial, but it was the same type of thing, right? That through cross-examination, they could establish the required evidence in order to go more into that if they so chose. The court concludes that at this time, defendant's alternate perpetrator proffer is inadmissible under Meister, as it is irrelevant and or excluded by Idaho Rules of Evidence 403. As you guys may well remember, Rule 403 is is it more prejudicial than probative, right? Things like will it tend to confuse the jury or cause an undue delay, things of that nature. And we also always refer to this as the balancing test, again, prejudicial versus probative. Relevancy is your rule 401, right? However, this does not foreclose the defendant from cross-examining law enforcement regarding the reasonableness of its investigation and its follow-up on plausible leads. So interesting how they're mentioning the investigation, because as we know with Karen Reed, there was a lot of overlap, right, with like the third-party culprit and the lack and the shitty investigation, right? There was a lot of overlap there, especially because for them, their third-party culprits, some of them were actually law enforcement, right? So here we're getting another kind of overlap here where, like, in other words, it's not just what he's saying is not to foreclose the defendant from cross-examining whatever, any lay witnesses, right? Specifically says for cross-examining law enforcement. So that's interesting. And then following up on plausible leads, again, very reminiscent of Karen Reed. And there's Twiz. There's Twiz. Hello, Twiz. Let me see what you guys are saying. Mary says it's raining. James is saying, thank you for everything I do. Thank you for always, James, I have to say thank you to you. Thank you for being awesome. And also thank you for always thanking me and being so supportive. Always. We love it. So again, anyone who wants to make sure that they are able to join us for the Twin Flames after this, make sure you've got your and right on cue. Mary gifted 5 memberships. Thank you so much. And congratulations to those of you guys who were gifted a membership. Thank you, thank you, thank you. That's awesome. It's like drunk shopping. There was that one live stream where Meg P gifted like a bazillion. It might have been like 150 memberships. That was pretty insane. And James got gifted. That's amazing. Love it. Love it. So I don't think we did Twiz's command yet. So let's do that just to make sure we're on point here. All right. So that means James and whoever else was gifted will be able to join us for the Twin Flames Insanity, which is going to be super fucking fun. All right. So here's the standard. This has been reiterated in every fucking filing, so I'm not going to read it again. Here's the analysis. The seminal Idaho case on the admissibility of alternative perpetrator evidence is Meister. So prior to Meister, a defendant wishing to present such evidence at trial had to first present, quote, proof of connection with the crime, such as a train of facts or circumstances as tend to clearly point out someone besides the accused as the guilty party. Remote acts, disconnected and outside of the crime itself, cannot be separately proved for such a purpose. And that's from State v. Larsen. That's been cited I recognize that. It's been cited before. Meister clarified that the Idaho rules of evidence, rather than the more onerous Larsen standard, control alternative perpetrator evidence admissibility. Okay. So under these rules, evidence is relevant. Okay, so let me reiterate what they're saying here. So again, the previous standard was this Larsen standard, which is saying that it has to prove a connection with the crime, right? To point out someone besides the guilty person, and it can't be too remote from the crime itself. The difference being that with the Meister standard, the change there is it seems to first really weigh the relevancy test, right? So under these rules, evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. So basically, it's a wider, it gives more range of possibilities, right? If it's first going to just look at, is it relevant versus like, does it definitively prove or point to someone besides the accused, right? So, and there's the Idaho Rules of Evidence 401, again, relevancy. Idaho Rule of Evidence 403 governs the exclusion of relevant evidence and permits a court to exclude evidence if its probative value, here's the balancing test, is substantially outweighed by danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Literally what I was just saying. Also, Idaho is here. Love it. Welcome, welcome. You guys have to make sure you check out The Adventures of Batcat because it's too cute. You guys will lose it. I have to watch it in doses. Between Batcat and Squeaky, it's overload for me on the cuteness because it's just so incredible. Definitely check that out. And also, glad you're here, Iowa. Okay, so Meister further offered the following guidance on applying these rules and determining whether proffered alternative perpetrator evidence is relevant and admissible. If the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable, then it is within the trial court's discretion to find the evidence admissible. Let me explain why I think this is actually really fair as far as a standard. And here's why. It really is just fleshing out rules 401 and 403, but as it pertains specifically to an alternative perpetrator. What do I mean? Well, the first part here is basically if the evidence that's been proffered is going to mislead the jury, right? That's part of 403, right? Or the evidence is not relevant because it does not make the defendant's involvement more or less probable. Well, that's rule 401, right? This makes a lot of sense as a standard. Mere inferences that another person could have committed the crime will most likely not be relevant. Interesting that it says most likely. So there's like possibility, you say. And if relevant, will still be subject to the limitation provisions of Idaho Rules of Evidence 403. A defendant has no right to present irrelevant evidence, right? And even if evidence is relevant, it may be excluded in certain cases, correct? Right? As we know, the first test of evidence is it relevant? Rule 401. After that, it's then submitted to the other tests in order to determine admissibility, right? But it starts with, is it relevant? The Idaho Rules of Evidence effectively safeguard against the admission of conjectural inferences without the lower courts needing to apply the Larsen direct connection doctrine. Right, there it is. The Larsen direct connection doctrine. Like I said, it was a far more rigorous standard with Larsen from, what was it, 1966, that now they use Meister, which is less, requires much less, it doesn't require the direct connection that Larsen did. So, and my state v. Meister's from 2009. So here, oh, and there's a footnote. Oh, we haven't gotten there yet. Okay. Here, the evidence the defendants offered purporting to establish the four individuals as alternate perpetrators objectively fails to meet the Meister standard, footnote 1. In addition, the evidence largely consists of inadmissible hearsay. Oh, ruh-roh. Defendant contends, however, that under Chambers v. Mississippi, which that is U.S. Supreme Court case law, hearsay tending to establish third-party culpability may be admissible. Let's continue to the rest of the footnote. Oh my God, look at the redactions. And the rest of that footnote is, no, sorry, it continues here. May be admissible to protect a defendant's constitutional rights to a fair trial and to present a defense under the 6th and 14th Amendments. Let's do this better. So, okay, in this U.S. Supreme Court case law, right, hearsay tending to establish third-party culpability may be admissible, oh my God, to protect a defendant's constitutional rights to a fair trial and to present a defense under the 6th. So what they're saying is there could be times, this is pretty subjective, isn't it? Could be times where the hearsay is still admissible in order to preserve a defendant's constitutional rights. That's interesting. What Chambers actually held is that an accused has a due process right to the admission of exculpatory hearsay. Oh, okay, I see. So, i.e. a confession by a third party. So that's when the hearsay could be allowed, right? Admissible if it's exculpatory, such as a confession by a third party. Okay. Provided it is accompanied by, quote, persuasive assurances of trustworthiness, end quote. Chambers stated, the testimony rejected by the trial court here bore persuasive assurances of trustworthiness and thus was well within the basic rationale of the exception for declarations against interest. Okay, correct. That's a good point. So when it comes to hearsay, right, as we know, there's like a ton of exceptions. So one of the times when hearsay might be admissible is when it's a declaration against interest. So for example, if let's just use this as an example, let's just say there's another person who's not being charged with a crime and they say, yep, I did it. That was a declaration against their own self-interest, right? So that could be an exception. That testimony also is critical to Chambers' defense. In these circumstances where constitutional rights directly affecting the ascertainment of guilt are implicated, the hearsay rule may not be applied mechanistically to defeat the ends of justice. In other words, Chambers indicates that due process requires hearsay rules to bend to evidence directly bearing on the determination of guilt. Okay, I'm here for it. It does not hold that unreliable evidence may be admitted simply because it may be relevant to the defense case. Okay, so in other words, once something like I said, right, relevancy is the first test. Once something passes the relevancy test, like I said, it still has to go through the other tests for admissibility. So here, after determining if it's relevant, let's say that we determine a statement is relevant, it then has to be determined if it's a hearsay statement that it's reliable. And one one exception to hearsay that can prove a statement to be reliable, as outlined here, would be a statement against self-interest, right? For example, as well, the reason being, right, because if somebody else is like, I did it, well, that really does not go well. That's not a good thing for them to say, right? So like, in other words, you can deem it to be reliable because it's not self-serving, for example. And there's Flash. I was just talking about you, Flash, in a good way, because we were talking about the chicken. Happy to see you, my friend. Let me see what y'all are saying in the chat. Also, shout out to Mr. Iowa. Please give him a big hug for me. And also all of the animals. We love Flash. We love Flash. And Flash has a membership, which is awesome. You'll be able to join us for the Twin Flames Insanity. Woohoo! Candace, welcome also to Candace. Also will be able to join us for the Twin Flames Insanity. Love it. Okay, so hopefully that all makes sense. If you guys have questions, let me know. I love talking about rules of evidence and admissibility, and I love talking about hearsay. So let me know if you all have questions about this. Okay. So, so as the court later stated, quote, the accused does not have an unfettered right to offer evidence that is incompetent, privileged, or otherwise inadmissible under the standard rules of evidence. Of course, that goes without saying, I feel like. Okay. So that was the footnote. I actually really enjoyed that footnote. So now we're going to carry on to where we were. So namely, the evidence is entirely irrelevant. Okay, well, that makes sense as to why it was all prefaced with that footnote, right? Why is it irrelevant? Well, let's keep reading. Nothing links these individuals to the homicides or otherwise gives rise to a reasonable inference that they committed the crime. So I'm wondering if maybe it's not the DNA, the other DNA, right? I guess it was unknown, but nothing links them to the homicide. I wonder who it is. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. Now, as far as who these people are, right, as we know right now, they don't have enough to make an offer of proof. But like we heard already, or read rather, they're able to have a wider latitude for cross-examination to try to develop this. So one way that during this trial, that we might be able to figure out who they're trying to build, right, as these 4 alternative perpetrators. If we pay attention to cross-examination, we might then be able to, we will be able to determine that, right? That will become, I think, quite clear. And Iowa has been a member for 4 months. Congratulations. Did you get an updated members only badge? For those of you guys who are members, you know how there's like the different badges that you get for different lengths of time. I have it set to different squirrels of the world because you guys are all squirrels of the world. And for anyone who didn't know, the first badge, wait, no, maybe it's the 1 month badge. There's a badge that you guys get that is actually legit Squeaky the Squirrel. The actual real deal Squeaky the Squirrel is one of the members only badges because Squeaky is a squirrel of the world, of course. So when we having game night, I don't know about game night, but the waterfall freaks are happening tonight when we finish reading these new filings. Twin Flames for the win. How common is it that someone gets retried 3 times? Not common. In Canada, okay, could be more common because in Canada, the rules are different. In Canada, what is it there? So in Canada, they don't have like double jeopardy, basically. So like if somebody, how does it go? If somebody is acquitted, that's what it is. If somebody is acquitted, the Crown can appeal it. Just like how here only the defendant can appeal if it's a criminal, if it's a criminal trial and there's an acquittal. They wouldn't appeal it, right? But like appellate. In other words, here, if it's a criminal trial and there's a conviction, you'll see the defendant, of course, appealing, right? But essentially, what they're saying in Canada, the Crown can also appeal for an unfavorable outcome. So if a defendant is acquitted, the Crown can appeal that. So essentially, there are no double jeopardy protections. And so in Canada, they're way more likely to try someone over and over and over again until they get a conviction. It's really fucked up, and Runkle talks about it quite a lot. Mary says she wanted all the smart liary people. Well, we do our best. Yeah, I don't know if there's a 4-month badge. I don't know that it allows you to do it. Like, in other words, you can't just like pick it. But I added badges for as many times as I possibly could. I think it's like 1 month, 2 months, 3 months, and then it might go to 6 months, and then it changes again. So, also, James put the link for Discord in the chat. Thank you for that. Oh, and literally, you read my mind. James also put the link for memberships. Thank you for that also. Awesome. Awesome. Squeaky the Squirrel. Is that a 1940s cartoon? I don't know. Iowa, did you weigh in on that? This kid was tried 3 times for murder. Interesting. Who was it? Oh, we have a new squirrel friend. Everybody, please welcome Amelia. Says, hey, new here. My husband told me to check out your channel, said I would love it, so here I am. Well, who is your husband? Because it must be another squirrel friend, but glad you're here. We love it. Is that you in that picture? Because that looks like a famous person. But welcome. Please feel free to join the Discord. Like we were just saying, I think you will love it here. We have a lot of fun. Yeah, it is very rare. I mean, I will say to that end, had Karen Reed been, had there been another hung jury on round 2, they would have done it. They would have gone again. It is rare, but there are, some exceptions. Karen Reed would have been an exception because that Commonwealth hates her, as you guys know. That is interesting, Mary. Yeah, it is. And you said it's a kid. It's like a juvenile, or so welcome to Amelia. Oh, you're okay. Thank you, Twiz. So you are Doug's wife. You know, it's really funny because Doug had a picture on his YouTube, and it was him with you, Amelia. And literally, I said to him the last time he was here, I was like, oh my gosh, your wife is gorgeous. So that makes sense. Are you a model? And I was following up. Badges are 1 month, 2, 4, and 12. Okay, thank you for that. Thank you. So if you've been here for 4 months, you don't get a new badge until you hit 12 months. But, hopefully you'll enjoy the 4-month squirrel badge. But we're glad you're here, Amelia. Yay. Woo. 20s, yeah, I feel you. 20s is a kid. I get you. I feel you on that one for sure. James is saying, welcome to the exceptional channel of Chelsea Whitaker Squirrel Crew. Thank you, James, for that also. And there's Miss Mojo. Welcome on in. Love it. You guys are here just in time. Y'all are, I think everybody's a member here, right? So that's awesome because, like, again, if you're just now joining us, this will redirect y'all into our members only live stream, and it will be really fun. Okay. So 3 of the individuals, footnote 2, we'll finish this sentence and then we'll read the footnote, were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicide, lived within walking distance of the crime scene, and were familiar with the layout of the victim's home from prior social events. Okay, so now we have some footnotes pertaining to that. And they're redacted, so we have no idea. Never mind. Okay. While perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of others in the victim's social circles, there's no compelling evidence that any of them had a motive to kill the victims. But you don't have to have motive. That's weird. And motive was not laid out in any of the case law either. That was not a requirement in the case law, much less physically harm them or a means to do so. Further, there is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. Now, here's what I will say. A lot of people might think that motive is a requirement for murder. It's not. Motive is not an element, right? However, it is oftentimes talked about because the jury usually wants motive. Now, what's interesting, right, is if you have a situation where a complete stranger has a first degree murder. I mean, this happens all the time, right? A lot of times, if you look at like serial killers, for example, it's like there really isn't a motive apart from the act of doing the killing, right? And so, you know, without going all the way into like serial sexual sadism or whatever, you know, that's a whole other thing. But the point being that you don't have to know the victims and have like a personal motive. Like, for example, other times where we get life insurance policy or an affair, one, you know, things of that nature. You don't, I mean, oftentimes these murders don't have an actual motive if it's, especially if you've got like a stranger, right? Further, there is no evidence connecting them to the crime scene. They have cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from. Okay, so the 4 people that the defense wants to suggest as alternate perpetrators are not in any way connected to the other DNA profiles that were found. Okay, the 4th individual, footnote 4, is this redacted? Yup. Oh, well, there's footnote 3, actually. The fact that these individuals lived within walking distance of the crime scene is not probative evidence, given that the perpetrator drove a vehicle to the crime scene. Further, none of these individuals drove a vehicle matching the description of the suspected killers. A description? You mean based off of the videos that are basically useless? Okay. If you ask me to describe the vehicle, the suspect vehicle in those videos, I would say it's a car, and that's all I can tell you. So anyway, lived within walking distance of the crime scene and were familiar with the layout of the victim's homes from prior social events. While perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of others in the victim's social circles, there is no compelling evidence that any of them had a motive to kill the victim. Oh, I already read this part because the motive part just is really annoying. So, okay, I already read that. So let me keep going. The 4th individual did not know the victims, but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. Noticing her. He followed her briefly out of the exit of the store while considering approaching her to talk. Interesting. He turned away before ever speaking to her. Well, this person does sound like maybe so far the strongest contender, right? Although a lot of this is redacted, so who knows. The event was captured on a surveillance camera. This individual subsequently cooperated with law enforcement, providing his phone number and a DNA sample. As with the other alleged alternate perpetrators, lab reports excluded his DNA from the samples taken from the crime scene and victims, and there is no evidence connecting him to the crime scene. Okay, let's see what y'all are saying. Right. Bryan was also excluded from the blood DNA and the DNA underneath Maddie's fingernails. Yep. I know, right? I mean, that's what I was literally thinking. I'm like, as we're reading this, I'm like, well, I mean, literally all of this could apply to the defendant, right? Apart from the DNA on the knife sheath when it comes to the DNA discussion anyway. But like, yeah, I mean, literally there's nothing that makes, by these standards, right? There's nothing that makes him a better suspect than the others, barring that touch DNA on the knife sheath. So, which is just frustrating. And thank you, James, is saying that I'm very fun, super smart. I do love cough drops. Thank you so much, James. Where's BK's motive? Hip, hip. Right, I know. It's like hip, hip, like hip, hip, hooray, but it's like hip, hip, boo. Where's Heather? Because she's going to want to be here for the Twin Flames. Anyways. Okay, so defendant, where was I? Collectively, defendant's proffer with regard to these 4 individuals fails to give rise to even an inference that they committed the crimes or otherwise make it more or less likely that the defendant was the perpetrator. Therefore, it is irrelevant under Rule 401. Defendant has provided no probative, admissible, significant evidence of motive, ill feelings, means, presence at the scene, or any other connection to the crime. This is really frustrating for me to read, right? It's like, are you reading? Are you listening? Are you hearing your own words, Judge Hippler? Are you reading your own words here? Or any other connection to the crime that could possibly move the ball to the extent it supports an alternate perpetrator theory. I mean, the thing is, right, is the only thing out of all of, like, none of this applies to the defendant, like he just stated, right? The only thing is that freaking DNA on the knife sheet. So all this would apply as well to Kohberger. At best, defendants offer, oh wait, hold on. Footnote 5. Can we read it? Okay. As the state notes, none of the 4 individuals drives a car that could be mistaken for a Hyundai Elantra. Well, and also, though, are we really sure it's a Hyundai Elantra? Because I don't know. So, okay, at best, defendant's offer of proof can give rise to only wild speculation that it is possible any one of these 4 individuals could have committed the crimes, which is inadequate under Meister. Again, mere inferences that another person could have committed the crime will most likely not be relevant. In other words, it is not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed the crime, which is all the defendant has done here. Why are we not seeing emphasis added? Emphasis was added with the italics. Why is it not say emphasis added? That's annoying. Even if there was a shred of probative value in the proffered evidence beyond wild speculation, it is excluded by Rule 403, the balancing test, as the 10th Circuit noted regarding alternate perpetrator evidence. It is not sufficient for a defendant merely to offer up unsupported speculation that another person may have done the crime. Such speculative blaming intensifies the grave risk of jury confusion, and it invites the jury to render its findings based on emotion or prejudice. Emotion? Anyway, so 10th Circuit. So for any of you guys who are like, 10th Circuit, that's the circuit for federal courts. And when it comes to the circuits, that's dealing with appeals. That's how they divide up the circuits there. Such speculative, oh wait, I already read that. Okay, that's from 1998. Likewise here, presentation of the proffered alternate perpetrator evidence would pose a great threat of confusing the issues because it would force the state to defend against a nebulous allegation that perhaps these individuals were involved. This feels very much reminiscent of Karen Reed trial number 1, where the Commonwealth's case in chief was basically defending against the third-party culprit from the defense, right? So in other words, here they're like saying, well, that's not fair to the state. Well, hang on. Hello, right? Like, fuck that. It's about what's fair to the defense. I mean, yeah, they have to make they have to have an offer of proof that will meet the standard, right? But the fact that the state's going to have to defend against an allegation in their case in chief shouldn't be involved, in my opinion, in terms of weighing this. This foray would lead the jury astray, turning its focus away from whether the defendant, the only person whose actions are on trial, committed the charged crimes. Oh my God, this is just so reminiscent of Karen Reed. It's wild, right? Like in trial number 1, it felt like Jen was on trial, Bryan Albert was on trial, Michael Proctor was on trial, Brian Higgins was on trial, Colin Albert was on trial, and probably missing people. It also presents a threat of unfair prejudice, as it would invite the jury to blame unrepresented persons for a heinous crime when there's not a scintilla of competent evidence connecting them to the crime. Finally, it would do nothing more than waste the precious time of the jury and the court in what is already a scheduled 3-month trial. Well, the length of the trial should not factor into the decision of whether or not to allow evidence, right? I don't like that he included this. You don't need that. Why include this? If you're already saying it's not relevant, it doesn't pass the admissibility test laid out by the other case law, then why are you including this? It's like, oh, well, it's already 3 months long, so we don't want to like take more time. Like that should not factor into this decision. Nevertheless, the court's ruling does not preclude the defendant from confronting and cross-examining the state's law enforcement witnesses regarding the thoroughness of the investigation, particularly in following up on and ruling out leads generally. Indeed, the Idaho Court of Appeals recently found in an unpublished opinion that questioning a detective about failing to follow up on other plausible leads was relevant to alternative perpetrator analysis. Quote, we agree with Emerson that a relevant line of inquiry would be to question the scope and breadth of the investigation and to explore on cross-examination whether plausible investigative leads about third parties were ignored or overlooked. Again, very reminiscent of Karen Reed. It further stated that this line of questioning may not include inquiries about the investigation of specific third parties, absent satisfying Meister. Okay, so in other words, you can't get into a specific person or persons unless you've first satisfied Meister. That doesn't surprise me. But okay, in terms of if anyone was like, well, how are they going to use through cross-examination? Like, how would the defense on cross-examination of law enforcement witnesses, how would they build, potentially have the possibility to build, enough evidence through the testimony to have established the necessary requirements for admissibility? Well, this is one way. So by questioning law enforcement about them not looking into inquiries without being specific about who, just like you didn't follow leads here or there or whatever, enough of that could potentially then allow, you could then potentially satisfy the requirements set out by Meister. And then once you've satisfied Meister, then you can go into specific people, right? While evidence challenging the thoroughness and reliability of the investigation might be probative, questioning whether law enforcement investigated specific individuals with no connection to the murder provided no probative evidence. Moreover, with no connection between the evidence and the crime, there's no explanation or justification for the questioning, and it would not help the jury answer the only question in the case, whether Emerson killed James. If in case you're like, who's Emerson and James, and we have James in the chat, not that James, this is from this other case, Meister. The court will apply these same parameters at trial regarding defendant's cross-examination of law enforcement. He may inquire as to the reasonableness of the investigation, including investigating and ruling out other leads. So this is really the important part, right? So it's not all is lost, right? It's not like flat. I mean, it's denied, but it's denied at this point. And again, we learned at the beginning of this filing that the defense conceded at oral argument, the part that we couldn't hear, they conceded that they don't have yet enough for that offer of proof. But here's the glimmer of hope, right? That they can inquire on cross-exam as to the reasonableness of the investigation, including investigating, ruling out other leads. And is it possible that potentially through this cross-examination, they could build enough to establish the requirements laid out by Meister? It's possible, totally possible. He is not, however, permitted to question law enforcement about the investigation of any specific individual as a potential alternate perpetrator without first raising the matter with the court outside the jury's presence. Again, if they can build enough with this general not ruling out leads, then they could approach to the bench and potentially have laid it out to where they can delve into specific, individual perpetrators. And if they do that, then that means they've met the Meister standard of admissibility, and then game on. If they meet that, if when we're at trial, if we hear them talking about Meister, this is what Meister is. Now we know, because it's Idaho case law specifically. And Meister, if they meet that standard, if they satisfy that standard, that means they can go into their alternate perpetrators as individuals or however they want to do it. Like they can go on, they can have a field day. And then based on the foregoing, it's denied. And I just want to add a caveat here. It's denied at this time because they still have the potential to establish the foundation on cross-exam. Okay, so let me see what you guys are saying in the chat. Oh, you're a very musical family. It's hard to read the chat when I'm reading the documents, but yeah, I'm a musician. You probably you've probably already gleaned that. I play a lot of instruments, but violin is my spirit, my life when it comes to music. And that's awesome that you have a musical family as well. I kind of got that impression from Doug. And in fact, how's he doing? I was trying to help him with his guitar. He was having some issues with restringing it. Like, I think he said he strung it backwards. So hopefully he's got that sorted out. Because we were talking about that the last time I saw him, which was, I don't know, maybe 2 weeks ago, maybe 1 week ago. I never tore into you, Flash. That's slander. Lies and slander. I mean, you guys know I'm vegan. I've never had fast food, but I don't care if people eat fast food or meat or whatever. You guys know that. But welcome, Happy Annie. I have not performed at Madison Square Garden. I've never even been to Madison Square Garden, actually. But would like to go. I love salad, although I only eat it once a day. But you're close with the salad there, James. I've never eaten animals. Correct. That is correct. Never eaten animals. In fact, if we do another members only live stream with Never Have I Ever, that's probably how some of you guys learned that, because I was like, never have I ever eaten meat or something is what I said on one of the times. Some of us are drunk. That's hilarious. Then sure, let's go for it. Sure, I performed at Madison Square Garden and Carnegie Hall while we're at it. How about that? Flash is spreading some rumors here. Yeah, right. I don't even know what a fish breather is. Okay, so next up we have the order on the motion to continue the trial, which is also denied. And again, I would expect that we will see, or potentially we will see, another motion from the defense to preclude the death penalty in lieu of the motion to continue being denied, which I think would be better for them anyway. Like, between the two, if you're the defense, you want to get rid of that death penalty. So. Yeah, I don't call people names. Well, I call, let's see. I guess if I'm like yelling at Bev or something, or Bryan, but like, yeah. Okay, anyway. Right, the 8-string guitar. He figured it out. He's in the Middle East. Wow. Dealing with that nonsense. Is that part of his job? I don't think I know what his job is. Or is he there for some other purpose? Glenn, well, we didn't call Glenn names. We just saying he's a troll, and that's like facts, but we never called him names. We were very, very nice to Glenn. We tolerated him for like 3 hours and 40 minutes. Oh, National Guard. Oh, I didn't know that. Thank you, Twiz. I don't even know what that is, Flash. We don't call you names, Twiz, unless except for your nickname, which is Twiz or Twiz Pants. Okay, so yeah, name calling isn't tolerated with me anyway, unless it's like there's some grave injustice happening, and then name calling is permitted to those who are perpetrating the grave injustice. Thank you, James. That is right. I do have do the orchid stuff. Okay. Yeah, feel free to say mean things about like people that are infringing upon constitutional rights and whatnot. Okay, so here we go. Redacted memorandum, decision and order on the motion to continue. I wonder what part's redacted. Well, we will find out. So, okay, before the court is the defense motion to continue the trial in this matter. The basis for the motion is threefold. First, he asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely, meaningfully review all of it. Again, not their strongest argument here, in my opinion. Second, he asserts that there's a penalty phase investigation and preparation that still needs to be done. A stronger argument than the first one, in my opinion. And third, asserts that recent and forthcoming publicity on the case is highly prejudicial. Now, that's getting warmer, but to me, it's not just the publicity, it's the leaks, right? And the fact that they need to be able to investigate the leaks because it could lead to exculpatory, Brady material. Okay. Maintaining the current trial setting under these circumstances, he argues, will render any conviction and sentence unconstitutional. The state responds that the defense motion is untimely, and he's failed to show either good cause for continuing the trial or prejudice that would result from maintaining the current trial setting. So shout out to all those of you guys who are school friends who have served, what do they say? See, I don't have anyone in my family who's, what do they call it? Oh my God. Military, I guess, is that the general umbrella term? So, because we got Mary, who was in the Marine Corps, and then Doug, who is in the National Guard. So, so shout out to all the people who serve the country. Is that the way to say it? You know, veterans and current people. So, okay. Right. Okay, we read the first paragraph. Carrying on. Oral argument on the motion was held on June 18th, and the court took the matter under advisement. The court finds the continuance is not warranted as defendant has not made a showing that there is good cause to continue the trial or that his substantial rights will be prejudiced by proceeding to trial as scheduled. Footnote 1. Defendant filed some of his supporting materials ex parte. Oh, that's right. That's why some of this is redacted. Okay. While the court is not convinced that much of his filing is necessary or appropriate to be treated as ex parte, the court will nevertheless, in an abundance of caution, issue a redacted and unredacted version of this order, which the state will only, with the state only receiving the redacted version, given that the court is denying the defendant's motion. Right. Okay. That makes sense. The standard. I don't think we really need the standard because we've already read this in other things and we've heard them argue it. We already know all this. So here's the analysis. Under Idaho law, a criminal defendant seeking a continuance of a trial must demonstrate that his or her substantial rights will be prejudiced, right? The burden of assembling the witnesses, lawyers, and jurors at the time and place of trial, counsels against continuances except for compelling reasons. There are no mechanical tests for deciding when a denial of a continuance is so arbitrary as to violate due process. Great, so it's completely subjective. The answer must be found in the circumstances present in every case, particularly in the reasons presented to the trial judge at the time. And as we know, this whole thing, the deference is going to go to the trial court judge, right? That if there's an appellate issue, they're going to say, well, we believe the trial court judge made the right decision because they're the ones who got to make that decision based on that particular case and right? Where a continuance is sought based on the late disclosure or discovery of evidence, the alleged tardiness of the discovery must be shown to so prejudice the defendant's case preparation that a fair trial would be denied. Fair claim that additional investigation could have been conducted is not sufficient. And then here, where continuance is sought for the potential receipt of evidence. So we heard Anne argue that, right? Like the potential of discovering new evidence. So they're saying that's speculative and based on this case law here. Defendant argues a continuance is necessary for him to sufficiently review relevant discovery, and then again conduct another further investigation. And then here, remedy the prejudice caused by recent and upcoming inflammatory publicity and the alleged leak of information to the media. Moving forward with trial, he warns will violate his rights under the constitutions. Absent from the defendant's materials, however, is any good cause for the continuance or legitimate showing of prejudice should the trial proceed as scheduled. It's a bit harsh. DJ Flashy Flash in the house. I don't have an OnlyFans. Lies. But we love DJ Flashy Flash. Okay, so defendant has not demonstrated a continuance is warranted to review discovery. Defendant first contends that the vast amount of discovery in this case renders it impossible for the defense team to review the necessary and relevant discovery in a manner that allows for it to be comprehensively integrated into his defense. He further argues, without any support or explanation, that there are a myriad of issues. So I would have assumed that they talked about this during the ex parte bit, but apparently they did not. Myriad of issues that continue to arise from the state failing to comply with discovery and expert disclosure deadlines, footnote 3. Defendant continues to complain of the state's, quote, discovery violations, end quote. But to be clear, the court has found no such violations by the state. Okay, so that's what Judge Hippler is saying. A continuance, he argues, is necessary for counsel to mount an effective defense. The court, however, rejected the same argument 2 months ago when the defendant sought to strike the death penalty and impose discovery obligations upon the state. And says it's referring to the order which we read when that came out. In its order, the court observed the utter lack of proof, yikes, supporting defendant's accusations of discovery violations by the state. More importantly, the court found the defendant's complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way that evidence, let alone relevant evidence, counsel had been unable to review over the past 2+ years, and why efforts to facilitate discovery review were not made long ago through this court and or the resource judge. So basically what they're saying is, and we've heard this, right? They could have sought for more resources, like, for example, more paralegals or maybe even another attorney, but basically more help. Like they could have asked for more help and they could have done that earlier. But at this juncture, to our knowledge, they've not asked for any additional help. Defendant's second round of this argument fares no better. He again fails to identify any relevant discovery that his counsel has yet to review. He fails to identify any steps his counsel has taken, particularly since the court's prior order, to aid in processing the yet unreviewed discovery. Again, I think what Judge Hippler would have liked to have seen is when this was discussed previously, the motion to strike, if at that point they had brought on more help, which was suggested they do, and then they brought on more help, and then here we are, it's still not enough. They would have had a much stronger argument here. But basically, Judge Hippler is like, look, I gave you an option. You had this available to you, and you didn't do it. So, like, there you go. That's basically what he's saying. Moreover, he does not explain why he waited to seek a continuance until after discovery closed, expert disclosure deadlines passed, and the pretrial conference occurred. If defense counsel was truly struggling with discovery review, this motion should have been brought when the claim problem became apparent, and should have been brought prior to the expiration of discovery, all expert deadlines, and final pretrial conference. Instead, defense counsel has robustly litigated this case, retaining approximately 24 experts and a full mitigation team, engaging in extensive motion practice and disclosing witness and exhibit lists with nary a whisper that a continuance would be sought. These actions belie his counsel's ongoing and ultimately empty discovery complaints. Wow, harsh words from Judge Hippler here. Harsh words. Relevant here, too, is the fact that defense counsel did not argue for a continuance as an alternate remedy to the defendant's attempt to strike the death penalty because of counsel's alleged. Did they not? I feel like my recollection is that they did. I thought they did, but maybe they didn't. He's saying they didn't. So this highlights that his claims regarding the volume of discovery were used as a tactical sword, untethered to a seriously legitimate concern about the ability to be prepared. He's using the word tethered. Has he been watching Karen Reed and hearing Mr. Leslie talk? Because we never really heard that word used a whole lot as pertains to law until now. Anyways, without more, the court can only conclude that defense counsel is using the volume of discovery measured in terabytes as a tactic to delay the proceeding at the 11th hour simply for the sake of delay rather than a legitimate threat of prejudice to the defendant's substantial rights. Perhaps even more problematic and more telling is the utter failure of defense counsel now or at any time to specify not only what needs to be reviewed, but importantly, when that review would be complete. So in other words, what he's saying here, and he's not wrong, what he's saying is they did not give an alternate date. They didn't say, look, if we had one more month, we'd be good. Or what if we start, whatever. They didn't. And I understand why that's a problem, because then it's like, when the state is going to argue, which they did, that they just want to continue it indefinitely, if you don't provide a time frame or an alternate date, then all you're doing is supporting that argument from the state, right? However, if the state's like, they just want to continue it indefinitely, it's like, no, we said it'd give us another month and we'd be good. Well, then it's like, then you've thwarted their argument, right? So instead, defendant seeks an unbounded continuance with no apparent plan to complete their review of unspecified evidence that counsel claims it has yet to review. This is not sufficient to warrant a continuance. Defendant has not established a continuance is necessary to conduct a more thorough life history investigation and identify necessary experts. So this is going to the mitigation evidence and the life history. Despite having hired a mitigation team 2 years ago, defense counsel contends that recently discovered something have raised red flags that the defendant may have, and then this is all fucking redacted. Oh, this is just stupid with the redactions here. Defendant has not, and that's because it's from the ex parte, okay. Defendant has not demonstrated a continuance to accommodate further investigation is constitutionally warranted, okay. And this has all been cited previously, so I'm not going to read all of it. The assertion that counsel needs the continuance to conduct an exhaustive and comprehensive dive into the defendant's life history for additional mitigation evidence overstates the extent of his counsel's constitutional obligations. Counsel's investigation into mitigation evidence must be reasonable. Well, but are they going to, is the law that going to determine the reasonableness standard for this particular test? Let's see. Because reasonable is in the eye of the beholder. The Idaho Supreme Court and the United States Supreme Court hold that defense counsel is not required to investigate a defendant's entire life in order to present constitutionally sufficient mitigation evidence. So this is literally the exact same citation provided by the state at oral argument. What's really funny, though, is the defense provided directly contradicting case law that they do have to do that. But Judge Hippler is choosing to agree with the case law provided by the state. We emphasize that Strickland does not require counsel to investigate every conceivable line of mitigating evidence, no matter how unlikely the effort would be to assist the defendant in sentencing. While defendant notes that the ABA guidelines for mitigation function, the defense teams, oh my God, that's a really long fucking title, urged counsel in death penalty cases to conduct an ongoing, exhaustive, and an independent investigation of every aspect of the client's character, history, records, and any circumstances of the offense. To meet their constitutional obligations, courts look not to what is prudent or appropriate, but only what is constitutionally compelled. I would say here that this standard, an ongoing, exhaustive investigation of every aspect of the client's character, history, records, and any circumstance. So here it's saying their entire history. Remember when I just said that they had something that directly contradicted the state's case law? Bam. There it is, right? Because what the state said and what Judge Hippler is agreeing with, not required to investigate entire life. Oh, you mean like an entire life history? And then here, the ABA guideline says the exact opposite. Okay. Roe, a capital case, is instructive here. On post-conviction, Roe argued her counsel was deficient because they failed to perform an adequate investigation. They said counsel should have investigated her life from birth to the sentencing hearing, that counsel were deficient in presenting her mental health workup. I mean, okay. So here's some of the things that the defense has brought out here that they would be using during the mitigation phase if he's found guilty. So the defendant's PhD education records, K through PhD, starting with kindergarten, including coursework, interviews, and correspondence, his mental health and medical records, including, it's redacted, records related to a childhood car accident, defendant's employment records, mental health, education, and employment records of the defendant's sisters, mental health records of the defendant's parents, father's military records and social security records, court records from multiple generations of the Kohberger family, paternal side, Virginia records and certificates from maternal and paternal uncles, multiple interviews with the defendant and each an immediate family member, interviews of 2 defendants' 4th grade teachers, former boxing coach, and a psychologist who evaluated the defendant in 2005, interviews with multiple members of the defendant's extended family on the maternal and paternal side, interviews with the defendant's professor and advisor at DeSales University, interviews of defendant's former coworker, interviews of at least 1 family friend, and letters and jail calls between the defendant and his family. Oh, jail calls, you say? It is evident from the reports of the defendant's mitigation experts that they have developed an expansive understanding of the defendant's family, environment, social development history, family history, educational history, and da da da. So they're saying he's not met this criteria. Despite such an extensive investigation, the defendant claims additional investigation is warranted to identify 1, redacted, and 2, redacted. Great. However, the defendant has not established that such investigation is constitutionally compelled. Okay. Further, defendant has not set forth a plan for continued investigation. How much time it will take? Again, it's clear that, I think that had they just simply, by they, I mean the defense, had they just simply said, had they given a time frame, that would have clearly made a difference, right, in how Judge Hippler interprets their argument. Would it have carried the day? I don't know. Maybe, maybe not, but it would have given them a better chance. Additionally, assuming guilt is found, the penalty phase of the case will not begin until late October or early November. So he's going to say there's plenty of time, right? Hey, redacted. Oh my God. And now here we're seeing, well, we already knew about this, right? But in terms of the ASD and whatnot, redacted. Notably missing from somebody's declaration is any indication as to how she intends to confirm her suspicions or how long she expects it to take, be that months, years, or even decades. Redacted. Oh my God, it's all redacted. None of defendants' somethings have raised the alarm that blah, 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 despite having the same information that someone relies upon. Wow, okay. Instead, it is an invitation for a perpetual continuance. Like I was saying, if you don't give them a time frame, by them, I mean the court or the state, you're literally inviting them to make these arguments, and they will indefinitely, perpetual, right? And so Amelia is saying, right, real concerned judge there, basically just a big F you. Yeah. How do we know the jurors can be honest when asked the questions? I wonder what juror questions the defense had objected to. Oh, you're talking about for voir dire. So as far as the voir dire goes, right? Well, we know from all these trials and tons of research is that the jurors generally are pretty honest. Where you run more of a risk of jurors maybe not being so honest is when you have the group jury impanelment, right? And that's because of that whole thing of like the societal pressure or wanting to look a certain way in front of your peers. But that is why, in terms of that issue or potential issue, that's where individual voir dire comes in. That's why that's so important. Because once you've like weeded out basically who literally needs to be disqualified from, and you've got a smaller pool, then you can begin the individual jury voir dire, and it's, one juror at a time. And then you can ask the more important questions, and the risk of them being dishonest, at least due to like the societal pressures, is not going to be an issue there. But it is, the studies do show that if they're in their group and they're being asked questions, they're going to care about, even if it's not intentional, right? If it could be subconscious, right? They want to look a certain way. They want to look like, there was a phrase used in one of these studies called, they want to look like a good juror, like in quotes, like they want to be the good juror. And and they want others to look at them as the good juror, like a good juror, like what does a model juror look like type thing. So they might answer something differently. But when you get them away from the group, then you get closer to the truth. And that's why individual voir dire is important. Where did Hippler say he doesn't have jurisdiction over the leaks? Is that in this document? Because I have not seen any follow-up from him. And he didn't say that at the hearing. So I'm wondering where you saw that, Twiz, where he weighed in on the leaks in jurisdiction. I would remember if I heard that or read that, and I have not yet. Anyways, James is saying I'm a great reader. Well, thank you, James. Thank you, thank you. Chaos. Shout out to DJ Flashy Flash with another what you would call it, alias, I do believe. Oh, I see. It's not a jurisdictional issue, right? You'd have to have a special prosecutor, right? Is that what you're kind of getting at, Twiz? Because yeah, it wouldn't be jurisdiction. It would be, you need a special prosecutor, somebody else who's completely unattached to the case. That's what would have to happen. But the thing is like, we don't know if that's happened or not, like if that's been appointed. So I feel like if that happens, we would see it in a filing, or at least we would see the title of a filing, even if the filing's redacted, and we've not seen it. So my thought is it probably hasn't happened. Could it still happen? Certainly could. Just putting some fun commands in the chat here. Okay, so wouldn't that be tainting the jury pool? Tainting the jury pool happens before you go to, well, tainting the jury pool is really referencing external sources like the media, right? And it's prior to voir dire starting. Being influenced by other jurors during voir dire isn't really considered jury pool taint. It's really just considered to be normal. And that's why you really, when you're there in the group, that's why you really just feel like feeling like who literally can't be here, who has like, you know, you're literally going from the most basic of things, right? Like people who are like, yeah, I already know he's good. They've already determined an opinion, or they're related to somebody, all the different things, like the basic things to rule people out, right? So that they're more like factual or logistical concerns versus like getting to their own personal philosophies and viewpoints and whatever. So yeah, it wouldn't be considered tainting from that. How could he get someone in trouble in Pennsylvania of FBI? I don't know what that means, Twiz. I'm not understanding. How could he get someone in trouble in, I don't know what you mean. Oh, okay. Well, that's what we're reading. So I guess I haven't gotten to that part yet, Twiz, because he says it's the filing from today about delaying the trial. That's what we're literally reading. This is the order on the motion to continue. So maybe I just need to keep reading to get to the part that you're talking about. Yeah, I mean, so my understanding was like that they were going to turn over their shit and then look into it, and if need be, appoint a special prosecutor to look into it further. So if that doesn't happen, it means that Judge Hippler has determined that there is no need for a special prosecutor. You know, and you can take from that, you know, right? Like, should he be the one making that decision? That's another question, right? But that's what will happen. He'll be the one that would make that decision as to whether or not special prosecutor is warranted and necessary. And if he doesn't appoint one, it means he found that there's no other issue to look into. If he does appoint one, and then he saw an issue that needs further investigation in his view, right? So, okay, more importantly, aside from the redacted shit, All this information has been available and documented in the record for months. Yet again, the defendant is only now moving for continuance or further investigation into unsupported suspicions, smacks of tactical gamesmanship and delay. Absent more compelling evidence that something. Okay, so basically just, yeah, deny. Okay, and then counsel's argument that more time is needed to investigate whether likely. So I wonder if this is dealing with the leaks here. Defendant has never moved for an extension to his oh no, this is going into like maybe the life history stuff. Defendant has never moved for an extension to his disclosure deadline for penalty phase experts so as to allow for further opinions in this regard. Okay. So this is dealing with like an expert that the defense maybe is wanting to consider bringing in, and he's saying no. Rather, is based on something speculation that the investigation might change. Okay. Neither the defense team nor something have articulated what efforts they have made, if any, since that time to understand the basis of whatever the thing is. Okay, it's dumb. Okay, so potential mitigation evidence. So after this, they'll get to the third grounds, which is going to be the leaks. Okay, so let's go to that part because we get it with mitigation evidence. Okay, here we go. A continuance is not warranted due to pretrial publicity. Defendant next seeks a continuance due to recent inflammatory pretrial publicity. On May 9th, approximately, okay, we already know about all this. We don't need to read this again. In addition, the defendant argues that a continuance is necessary to investigate the source of leaks to the media and impose accountability. The court does not agree that either argument compels a continuance. He's saying this time is not going to help anything. That's his first thing he's saying here. This statement from Shepard must be read in context. The media coverage in this case is far different from that present here. Okay. So he's just making a distinction between the case law that the defense cited and how it doesn't apply to this case. Carnival atmosphere. I remember we've gone through all this. It's been in other filings. I think this was also cited in the motion to change venue as well. So this is not new. None of this is really new. Let's get to the part about the freaking leaks here. Okay, media sensation. Okay, here we go. A continuance is not warranted to investigate the leak of information. Defendant also asserts that continuance is necessary to accommodate the special prosecutor's investigation. So, okay, well, I'm going to take you guys remember what I was just saying about the special prosecutor? That has happened. Let me read this again. Defendant also asserts that a continuance is necessary to accommodate the special prosecutor's investigation. So it sounds like they've already appointed a special prosecutor and they're already looking into it. Interesting. Into the source of the leaks to the media and to oppose accountability. With regard to the Dateline episode, defendant points out that the Dateline represented that the material came from sources close to the investigation, right? Okay. He argues that if any of the leaks came from witnesses the state intends to call or from others involved in the investigation, the information is Brady material because it would serve to impeach the leaker's credibility and may be exculpatory in nature. Footnote 25. Pursuant to Brady, the prosecutor has a constitutional duty to disclose favorable evidence where the evidence is material either to guilt or punishment. This duty covers and then Giglio, right? So really, it's not Brady, it's Giglio is really kind of what they're going with here. So he's kind of correcting them there, I guess. So He adds that if the investigation reveals that other state agents had information about the leaks but failed to disclose it, this omission would constitute a Brady violation. As noted, a continuance is not warranted where the information sought thereby is mere speculation. Defendant's Brady argument is built on a house of speculative assumptions. An assumption that there was a leak by persons bound by the non-dissemination order, an assumption that the leakers will be found, an assumption that the leakers were law enforcement. Footnote 26. While the court observed in its document and records hold order that it appeared likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order, it could have been someone from the defense team. Oh, okay, that's new. Or someone not subject to the non-dissemination order. He's completely changing his tune because he made it very clear that what he thought, okay, well, I don't like it. I don't like it at all. I don't like this at all. I don't like this at all. We all heard him, dude. The court has not made and was not by this statement making a finding or otherwise accusing law enforcement or the prosecution of stuff. So he's like, to me, this is like he's doing a 180 because he's like, wait, I don't want the fallout to happen here. An assumption that the leakers or others who may be were complicit will be testifying as government witnesses, and an assumption that the witnesses will likely be material. Such assumptions are not grounds for continuance. They're only assumptions because they haven't had time to fully investigate it. That's why you need the continuance, so that if you have more time to look into it, then you wouldn't have to be making assumptions. Hippler. Particularly given that there's no guarantee if and when they will be confirmed or debunked. This trial cannot be held hostage indefinitely to the outcome of the investigation, particularly given the very significant chance the leaker may never be discovered. 27. In addition, even assuming it was law enforcement who leaked the information, the FBI played a preeminent role in the investigation of this case. If leaks were from the FBI, a state court's ability to further investigate is highly circumscribed and limited, if not altogether foreclosed. In addition, law enforcement in Pennsylvania and Washington may have had formal or informal access to some of the evidence, yet an Idaho state court may have had significant limitations on the ability to investigate them. Huh. I see what why Twiz said jurisdiction. This just sounds like excuses to me. There's not a jurisdictional issue. While it's true that it's tough sometimes to get, discovery and information from the feds, and they do what they want, as we all know how that works, right? The feds. It is not just like this blanket thing of like, well, let's just say the leaks from the FBI, well, too bad, so sad. Or let's just say the leaks from Washington or Pennsylvania. Not at all. Not at all. Not at all. This is excuses, in my opinion. You'll notice he's not provided anything to support this, right? You'll notice there's nothing to support this, whether it be case law, whether it be anything factual, right? Whether it be a statute, whether it be U.S. code, there is nothing to support this. So that should give you red flags right off the bat. He's literally just making this assertion that the investigation would be pointless after first making it sound like he thought the investigation was really fucking important. Dude, what did he think was going to happen? And it really, okay, I'm going to keep reading because we're almost done. Thus, the court will not continue the trial pending the results of an investigation based on speculation that it will be successful and hope that impeachment. I'm just shaking my head, guys, here because, like, he's speculating. He is the hypocrisy. You guys know how I feel about hypocrisy. He is speculating. He's speculating that the investigation would be. He's speculating that there's only speculation here, right? You need to investigate. Like I said, the cure for speculation is investigating the things, right? Yes, sometimes there's speculation in other matters. Like there's oftentimes things that are speculation. But here, that's not the case because this is a new thing that just started happening and they only just started looking at, they got the special process. Like there's not been enough time. Like, yes, Of course, now it's only speculation because there hasn't been enough time. So he's speculating that the results that would be yielded would only yield more speculation. This is like the snake eating its tail argument. I just can't stand this type of shit. It's like a logical fallacy mixed with a bunch of hypocrisy, and it's all the things that I hate. So there we go. Done. You guys. Well, if Steve or anybody got the info, and they got the info from law enforcement, that whoever those law enforcement people are or person, they are responsible, and they are held to the standards that they are under the gag order, right? Like, if we went through this rigorously, right? That then, as far as the non-dissemination order goes, if somebody who has this, who's a party to the case, right? Whether it be a law enforcement officer or whatever, if you're a party to this case, right? And what we know when it comes to prosecution, that's actually a really wide umbrella. It includes all the law enforcement, includes all the people who did, forensic evidence, whatever. And they provide a detail to someone where there's a strong likelihood that that person will disseminate it. So even if the initial person, let's just say it's Officer Brown. I'm making this up, right? Let's just say it's Officer Brown. Maybe Officer Brown doesn't go spreading it to a bunch of people. If Officer Brown provides this information to someone where it goes to the reasonableness standard, that they reasonably knew or should have known that whoever they spread it, they told one person, but they know that person is a blabbermouth, for example, they're liable for that. And I said this at the time when we went through it. I literally said, any person who provides information to Mr. Gonsalves would do so knowing it's going to get disseminated. Literally, like, of all of the people, that's all. That to me is intentional. That would be an intentional, not just negligent, not just a mistake. That would be an intentional choice to provide that information to him, because you literally, the only one that could have been worse is going straight to, like, Nancy Grace, for example, right? So while Mr. Gonsalves can't be liable, whoever told him anything, if somebody told him something and that person is covered by the gag order, that person or persons is responsible and in violation of the court order. So good night, Candace. We love you. So we are done with these filings, guys. So as always, we'll keep ourselves apprised as whatever else comes out. But for now, guess what? It's time to redirect into our members only live stream. So get ready for some twin flames insanity. Are you guys excited? I'm excited. So through the magic of technology, let's shut on over, and I'll see you guys on the other side here in just a minute.